Good evening, good afternoon, wherever you are in this great country of ours, north side, south side, east coast, west coast. Welcome to the drama-free true crime destination known as Bethea'S Byte Reloaded. I'm Ernest Bethea, the last outlaw. So good to have you here with me. We've got a lot, and I do mean a lot, to get to. If anybody missed my post on the community page, I had to update everything that I have on tap today. So if you missed that, check that. Be back here so we can talk about it. Let's get everything covered. We're gonna go ahead and kick start this thing with our missing persons update. Please take a look at your screen. This is Maribel Oquendo Carrero. She goes by the aliases Maribel Oquendo, Maribel Oquenda Carrera, and Marilyn Oquendo. She's missing out of Camden, New Jersey. At the time of her disappearance, she stood about 4 feet 3 inches tall, weighed around 54 pounds, with black hair and brown eyes. The FBI is currently offering a $25,000 reward for information leading to her recovery, or the identification, arrest, and conviction of the person responsible for her disappearance. Maribel has ties to Puerto Rico, New Jersey, New York, and Florida. On December 6, 1982, Maribel Oquendo Carrero left her home in Homestead, Florida to walk to the corner store. Family members report she made it to the store and purchased items, but she has not been seen or heard from since. At the time she went missing, she was just 9 years old, wearing a white t-shirt, blue and pink pants, and new beige and brown shoes. Both of Maribel's ears are pierced. As always, if you have any information on the whereabouts of Maribel Oquendo Carrero, please do not hesitate. We're asking you call 911 immediately, contact your local FBI office, in this case, the field office in Miami, or submit your tip online at tips.fbi.gov. I will have this information posted in a separate video later. But still, your help is desperately needed for this young lady. Right as you see from the photo on the left, that's when she was around, I say, 9 years of age, and on the right, this is a photograph age progressed to age 47. She is now she'll be 50 later this year. Let's go out. Let's find Maribel. Let's bring her home safe. If you see something, ladies and gentlemen, please, whatever you do, say something. Whew, okay, now that we got that part out of the way, I've got two viewers right now. I would love to hear from you guys. So why don't you come on in the chat? Don't be scared. I don't bite hard. I've got a lot. Like I said, I've got a lineup of a myriad of things to go through today. So let me go ahead and begin at the top of my list. I've got a couple of updates on both the mom at the center of. I've got a couple of updates regarding the mom who was charged with neglecting her 5 children after police found them in the basement. Found in the basement, malnourished, and all those kids weigh less than 100 and no, excuse me, they weigh less than 55 pounds. Now, let me pull that article up. All right. Let me get your eyes. Let's share this screen. Okay. Okay, on your left is Daisha Turner. Daisha Turner is the Wisconsin mother who had her kids in the basement. This is the article with the update. Wisconsin mother's bail is set at $1 million on last Thursday after I'm saying last Thursday because that's when it was. After prosecutors said 5 children were severely malnourished and neglected in a basement. Daisha Turner, age 34, was charged with 5 felony counts of neglecting a child. On July 31st, Racine police were dispatched to a home to help CPS investigators with a welfare check on 5 children that had been staying in the basement. The children's ages of 14, 8, 7, 2, and 14 months. As you can see from the photo in front of you. Remember the photo on the left. That's her. This was her booking photo as of August 7th. I'm gonna jump right ahead, and this is the update. She's her case has been postponed. Says a Racine mother with 5 charged with child neglect will have to wait until next month to find out if she'll be ordered to stand trial, which is likely. Daisha Turner had a preliminary hearing on August 16th, and it was rescheduled when she appeared without a public defender. Turner is accused of locking her children, ages 1 to 14, in a basement. Multiple complaints to Child Protective Services in both Racine and Kenosha County show the kids were malnourished and rarely got a bath or shower. Turner was due back in court on September 27th. Now, oh my goodness! Welcome to the chat, Soul Shine for Jesus. It's good to have you here. Yeah. Anyway, I was saying about Daisha Turner, the person on the left side of your screen. She'll have to wait till next month before she finds out if she's ordered to stand trial because she was ordered to she didn't come in and Haunting Haley. It's good to see you and good for you to be here too. Wow. I appreciate you guys coming. I'm gonna try and say this yet again. Hold on. Wow. Savizan, how you doing? Great to have you on. Great to have you on. All right. Daisha Turner on the left side of your screen. She will have to wait until next month to find out if she'll be ordered to stand trial because she showed up to her August 16th hearing without a public defender. So that's going to be a wait and see case. Now, next up is the lady on the right side of your screen, Sushi Staples. She's accused of concealing the death of her son, Zion Staples. 10-year-old boy found dead in a garbage can in Rock Island, Illinois, in the garage of his mother's home, and now the mom faces charges, according to multiple reports. The Rock Island Police Department launched a probe into a suspicious death at the home, according to a press release. Police found Zion Staples' body at a home after being in the trash for 7 months. Authorities report that the child's mother, 37-year-old Sushi Staples, is being charged with concealment of a death, failure to report the death of a child under 13, and obstruction of justice. Now, keeping in mind, this is still an ongoing investigation. She appeared in court or had a preliminary hearing on August 15th. They don't know if she's entered a plea or retained an attorney, but like I said, the case is still ongoing. If anyone has any information on this particular case, you're being asked to contact the Rock Island Police Department at area code 309-732-2677 or call the Illinois Crime Stoppers at 309-762-9500. Again, those numbers direct to the Rock Island Police Department is 309-732-2677 or Illinois Crime Stoppers at 309-762-9500. Ladies and gentlemen, I really don't know what to make of these two cases. Oh, let's see what we got here. What we had in the comments. Don't feel bad. Don't ever feel bad about misspeaking. I've been doing this for a year, and sometimes I have to just tell my chat, y'all, I'm not even trying that word again. Thanks for that, Haley. I love it. Let's see. Sounds like the county failed her by not sending representation. Well, I won't say they failed her yet, simply because she didn't have representation this time doesn't mean she won't do it. It won't happen the next time. And yeah, poor baby. Yeah, I totally agree. And that's on not just in this case, but the case I mentioned before that. Soul shine for Jesus Christ. That's how she's feeling too. Well, I'm just hoping and praying that in both of these cases, the children of these two moms, and I put that in air quotes, get the justice they deserve. I mean, you got one here. We got one that is hiding, that is concealing her son's death. Then you got the other totally neglecting her 5 kids. Oh, and did I mention that each one of her 5 kids weighed less than 55 pounds? Yes, I kid you not. How bad is that? Let me put it to you this way. Let me put this in terms of the youngest. For a 14-month-old child, the average weight is 26 pounds. This 14-month-old weighed only 10 pounds. Let's see if that math works for you. Let's see. Soulshine says it's awful. Yes, it is. Yes, it is. Doesn't look like no, not at all. Not at all. Not at all. She's eating fine. Soulshine, I cannot even understand how you starve your babies. I'd go without a drop of food to feed them. I don't blame you. I would too. Let's see, Haley. My 22-month-old is long and tall, almost 30 pounds. There you go. Savi's aunt, my brother was more than 10 pounds when he was born. Well, there you go. That's telling you something right there. That's telling you something right there. Like I said, let's just hope these two, the children of these two women, moms in name only, get the justice they deserve. All right, let's see what I got next. Oh my gosh, I forgot that I had I saved links for all this. These are let me start with Daisha Turner first. This is when this, if I can pull, I'm pulling this up right at the moment. This is where she was arrested. Hold up. You know what I gotta pull up the old copyright disclaimer before I start showing anything as far as videos go. All right. All right, there you go. There's your copyright disclaimer, ladies and gentlemen. And now,
a mother of 5 awaiting charges tonight for child neglect after her kids were found in a basement living in terrible conditions. CBS 58's Yukari Nakayama talked to the father of one of those kids today.
On Monday, Daisha Turner was arrested on suspicions of child neglect after the Human Services Department discovered her children living in improper conditions and appeared malnourished.
CPS called me. That was what the first. They called me and told me they found my son and his siblings in the basement abandoned.
On July 31st, around 3:34 p.m., Racine Police and the Human Services Department arrived to a home near Metron Court in regards to a welfare check of children living in a basement. Racine Police say Human Services personnel believed the children appeared malnourished and did not have proper living conditions.
32 pounds. 7 years old.
Ricky Stevens says he hasn't seen his son, one of the 5 children, in 3 years, alleging Turner would not allow contact between the two. He said his heart broke when he heard the news about Turner's alleged neglect.
I was messed up, hurt. My son would never have to go through that again.
Stevens says he's been told his son is recovering and eating well. The children were taken to the hospital for evaluation. And on July 31st, Turner was sent to jail for a warrant. After a follow-up investigation, Turner was arrested on Monday.
I hope they give her life. You commit, that's attempted murder to all 5 of them kids to me.
Ricky Stevens says he's in the process of trying to get custody of his son, hoping that they'll be reunited soon. Turner's bond is set to $250,000 and charges are still pending. In Racine, Yukari Nakayama, CBS 58 News.
Thanks to CBS 58 for that update. And like I've been getting in the chat, it is seriously a shame how these so-called moms can abuse, neglect, murder, or even cover up the death of a child. Need further proof? Let's take a look at TV6 in Illinois as we investigate one Sushi Staples.
Charged with hiding the body of her 10-year-old son. The boy's body was found in their garage. last week. I'm Paula Sands.
And I'm Redrick Terry. This discovery happened at a home on 20th and a half Avenue near 17th Street. TV6 Investigates Matt Christensen was there today and spoke with the next door neighbors.
Sushi Staples has been arrested for concealing the body of her 10-year-old son, Zion, in the garage of this Rock Island home. We talked to neighbors in the neighborhood today who said that the family was a normal Christian family. Andre and Danielle Bilta have been renovating the home next door and moved in last month. The Biltas said there was never any indication of a grisly crime. They said a happy family lived here.
We saw two girls, coming sometimes like out in the yard. I saw them drawing with chalk in the back driveway.
Playing with scooters out front of the garage. Everything seemed really normal.
They would wave when they saw us, and so we were like, oh, they seem pretty friendly actually for neighbors.
The girls were playing just a few feet from where prosecutors say Staples was hiding her son's body. Sometimes the neighbors talked about church.
And, she was like, oh, hey, I'm a Christian too. And so we were talking about that, but we were like, that's cool. Here's info about our church. And she was like, I don't really have a church right now.
Meanwhile, Staples has been charged with 4 felonies, including obstruction of justice and concealing the body. The Biltas said it's like something out of a movie.
It's a little weird because all the time that we've been here working on the house and knowing her, knowing what was in the garage, literally
we walked
30 feet from the house that we've moved into, a little bit worrying, kind of scary, but it was quite a surprise. I wasn't expecting it at all.
An autopsy was performed Friday in Rockford. No one has been charged in the boy's death. Reporting in Rock Island, Matt Christensen, TV6 Investigates.
And Rock Island police said today that there were no new updates in the case.
And a big thank you to TV6 for breaking down the arrest of Sushi Staples. But right now they said that at the moment there's no major updates in the case, but when there is, I'll be sure to get it to you. Moving onward. Next up. Now I know the next on my docket. I know you've heard about it in a lot of different cases, on other channels. This one, I'm happy. I'm more than happy to do because I started on it. I got lax on it, but I'm so glad I'm able to have an update on this one. This one involves the British former neonatal nurse Lucy Letby. And when I say good news, I'm talking about the news is so good, I had to put this one right where it belongs, under justice served. So give me 1 second. Give me 1 second. Give me 1 second. Copy that. And once again, got a copyright disclaimer for this. And now we're going to take you across the pond for this report as we find out the verdict in Lucy Letby's case.
Minutes, we got those headlines, and disturbing as they are, there will be at least some sense perhaps of justice for the parents. They now have a guilty verdict, and the person will spend doubtless a long time in jail as a result of this. Just give us an idea of how that news broke in the last 15 minutes.
Exactly. Well, the jury were called back in at just before 1 o'clock, and in the presence of the families at Manchester Crown Court, lots of the families, around 15 family members, were present in court, and the judge said that on the charges, Lucy Letby had found guilty of murdering 7 babies. She was found guilty of 7 further attempts to murder a further 6 babies, and she was found not guilty of 2. On the remaining counts, the jury could not reach a verdict, and therefore they have been discharged. The judge thanked them for their service, and Lucy Letby will be sentenced on those charges that the jury was able to reach a verdict on Monday. Now, Lucy Letby has been present in court up until earlier this week, but she was noticeably absent today after we were told yesterday that she would no longer be attending court. Her parents likewise have been in court for the duration of this trial and also for those 22 days that we have been in deliberation. Her parents were not present in court today, and as you say, it will be a relief. This trial has been going on since October last year. The jury have been deliberating for more than 110 hours, and so at least it will be some relief that this process for the moment has come to an end. Of course, now for them, though, there is still further pain ahead, especially as she was found guilty on the murder of those 7 babies.
Victoria, what do we know about sentencing? Any idea when specifically that might happen?
At this point, we are thinking that the sentencing will take place here at Manchester Crown Court on Monday on those charges on which the jury was able to reach a verdict. And obviously on those other counts, those other 6 counts, they were not able to reach a verdict.
I'm gonna stop this right there. As good as that seems, I really do not want to keep you guys waiting as far as Letby's sentencing. Remember, guys, my original slogan for this channel is news, opinions, debates, your voice, and justice served. I plan with this particular video. I believe I can say that I'm living up to the back end of that slogan pretty nicely. Wouldn't you agree? So, without further ado, here is the sentencing of Lucy Letby.
Lucy Letby, over a period of almost 13 months between June 2015 and June 2016, when in your mid-20s and employed as a neonatal nurse in the Countess of Chester Hospital in Chester with specialist training in intensive care, you murdered 7 babies and attempted to murder 6 others. In the case of one of them, trying on separate occasions 2 weeks apart to murder her. You are now to be sentenced for your crimes. I order payment of the statutory surcharge in the appropriate amount. You acted in a way that was completely contrary to the normal human instincts of nurturing and caring for babies, and in gross breach of the trust that all citizens placed in those who work in the medical and caring professions. The babies you harmed were born prematurely, and some were at risk of not surviving. But in each case, you deliberately harmed them, intending to kill them. In your evidence, you said that hurting a baby is completely against everything that being a nurse is, as indeed it should be. You also claimed you never did anything that was meant to hurt a baby, and only ever did your best to care for them. That was but one of the many lies you were found to have told in this case. There is no doubt that you are intelligent and outwardly were a very conscientious, hard-working, knowledgeable, confident and professional nurse, which enabled you repeatedly to harm babies on the unit without arousing suspicion for some time. You prided yourself in your competence. Your fellow neonatal nurses spoke very highly of you, and several of them became your close friends. Having started as a Band 5 nurse at the Countess of Chester in 2012, you became a mentor to student nurses, and in the spring of 2015 gained the qualification that enabled you to care for the sickest babies on the unit or those requiring the most intensive care. You relished being in the intensive care nursery. Your messages to colleagues revealed an interest in babies that were on or were coming to the unit who had uncommon medical conditions. The methods you employed to carry out your murderous intent were only revealed by the later detailed investigation into the events of and surrounding the collapses and deaths of the babies, which commenced in 2018. There was premeditation, calculation, and cunning in your actions. You specifically targeted twins and latterly triplets. Some babies were healthy, others had medical issues of which you were aware. The great majority of your victims suffered acute pain as a result of what you did to them. They all fought for survival. Some, sadly, struggled in vain and died. You used a number of different ways to try to kill them, thereby misleading clinicians into believing the collapses had or might have had a natural cause or were a consequence of a developing medical condition. You took opportunities to harm babies when staff were in breaks or away from babies. On some occasions, you falsified records to indicate there were signs of a deterioration before a collapse occurred. You knew that the last thing anyone working in the unit would or did think was that someone caring for the babies was deliberately harming them. As the number of unexpected and unexplained collapses and deaths escalated, senior doctors started to think the unthinkable and consider the possibility that someone was, in fact, deliberately harming the babies, and you were identified as the common factor. You had a detached enthusiasm for the resuscitations and what followed. You endeavoured to impress colleagues and clinicians and sought reassurance from them as to your competence and skills, and would message others to the effect that no one was at fault. On occasions, you cruelly and callously made inappropriate remarks to some of the grieving parents at the time of or in the immediate aftermath of a death. When the homes of both you and your parents were searched, confidential documents relating to babies, including handover and resuscitation sheets and notes and blood gas readings, were found, and there were entries in a diary recording relevant events. Handover sheets relating to all but the first 4 of the babies had been taken from the unit and kept by you. I am satisfied you started to keep these documents after those initial offences in June 2015 as morbid records of the dreadful events surrounding the collapses of your victims and what you had done to them. You had a fascination with the babies and their families, which extended to making repeated searches on Facebook for their parents, sometimes immediately following the events, and on occasions much later. A piece of paper with dent writing on both sides, setting out your thoughts and feelings, was found in the first search of your home in 2018. Amongst the phrases you wrote were, "The world is better off without me," and "I am evil, I did this." The impact of your crimes has been immense, as disclosed by the deeply moving personal statements that have been read to the court this morning. The lives of newborn or relatively newborn babies were ended almost as soon as they began, and lifelong harm has been caused, all in horrific circumstances. Loving parents have been robbed of their cherished children, and others have to live with the physical and mental consequences of your actions. Siblings have been deprived of brothers and sisters. You have caused a deep psychological trauma, brought enduring grief and feelings of guilt, caused strains in relationships, and disruption to the lives of all the families of all your victims. It is no part of my function to reach conclusions as to the underlying reason or reasons for your actions, nor could I, for they are known only to you. I must pass appropriate sentences according to law, addressing the seriousness of your offences, the facts of which I now describe briefly. The cruelty and calculation of your actions were truly horrific. After these last collapses and deaths, you were suspended from nursing duties, but pursued complaints of being treated unfairly. When your home was later searched, as well as your 2016 diary, which contained references to long days on the 23rd, 24th and 25th of June, and to J, E and M, respectively, there were handover sheets over that period with resuscitation notes written on the back. All, I have no doubt, being records that you kept to remind you of the details of the consequences of what you had done to those children. For the offence of murder, the sentence is fixed by law and is imprisonment for life. You are now 33 years of age and were over 21 when you committed the offences. Pursuant to the relevant prevailing statutory regime, by having regard to Schedule 21 to the Criminal Justice Act 2003, I have to determine whether the seriousness of the offences of murder, individually or in combination, is so exceptionally high that I should not make a minimum term order and you should spend the rest of your life in prison. For offences of attempted murder, whole life sentences of imprisonment are reserved for wholly exceptional cases. Over a period of just under 13 months, you killed 7 fragile babies and attempted to kill 6 others. Some of your victims were only a day or a few days old. All were extremely vulnerable. They were in a hospital where others were striving to provide them with dedicated medical and nursing care. By their nature and number, such murders and attempted murders by a neonatal nurse entrusted to care for them are offences of very exceptional seriousness. The damaging impact of your actions on others working at that hospital, including those who numbered you as a friend, betraying their trust and creating upset and suspicion, as well as eroding confidence in clinicians and nurses generally, aggravates their seriousness. This was a cruel, calculated, and cynical campaign of child murder involving the smallest and most vulnerable of children, knowing that your actions were causing significant physical suffering and would cause untold mental suffering. You created situations so that collapses or causes of collapses would not be obvious or associated with you. You removed and retained confidential records of events relating to your crimes and checked up on bereaved parents. There was a deep malevolence bordering on sadism in your actions. During the course of this trial, you have coldly denied any responsibility for your wrongdoing and sought to attribute some fault to others. You have no remorse. There are no mitigating factors. In their totality, the offences of murder and attempted murder were of exceptionally high seriousness, and just punishment, according to law, requires a whole life order. Lucy Letby, on each of the 7 offences of murder and the 7 offences of attempted murder, I sentence you to imprisonment for life. Because the seriousness of your offences is exceptionally high, I direct that the early release provisions do not apply. The order of the court, therefore, is a whole life order on each and every offence, and you will spend the rest of your life in prison.
You guys ask for life? You got it. Lucy Letby will not see the light of day. Nope. Whatever the UK system of parole, whatever that is, she will not see that either. The situation was too grave in the eyes of Judge Goss, and like he basically said, this woman has no business being a neonatal nurse if she's going to kill babies. Those who can barely, no, I can't say barely, they can't even protect themselves. Like he mentioned that the babies were anywhere between a day and just a couple of days old. Come on. Even if that happened here in America, the parole would be an afterthought. This woman would indeed spend the rest of her life behind bars. So yes, file that under justice served. And speaking of which, got another sentencing too. Mackenzie Shrilla was on trial for the deaths of 2 in a car crash. She was convicted. And we're going to go to sentencing courtesy of my good friends at Court TV. So, let's see. But before we go there, I can't. I'm tongue tied this afternoon. Soul Shine for Jesus Christ said, "This is absolutely hard. My heart cannot comprehend this evil." Soul Shine, evil can come from anywhere. We have so many people putting themselves in spots where they're supposed to look like the hero, look like the good guy, but undercover they are just, as you said, pure evil. And now, like I said, when it comes to justice served, we have another one on this. I'm gonna play the sentencing for this young lady who was convicted of killing 2 in a crash. Again, shout out to my friends from Court TV for the coverage.
He made friends easily with his infectious smile. He was a gifted athlete. He had plans to go to barber school and open his own shop. My son did not have a clique of friends, but instead was a friend to all. He would go out of his way to show love and kindness to others, including those that were often cast aside by society, the less fortunate, the developmentally challenged, the hurting, and the unvalued. Davion made sure that everyone that crossed his path knew that he truly saw them, that he valued them, and that they were worth his time. Davion and my kids have had more than their fair share of heartbreak, of hardship, and of loss. Davion was adopted with his sisters from foster care. They are biological siblings. We are honored to be chosen, or to have been chosen, to be their parents. Their forever family. I am devastated by the loss of Davion. The world lost a truly special man. My girls lost their best friend, their protector, the one and only trusted family that has been by their side from day one. This alone, or he alone, understands the pain and loss that they have gone through and was always there for them. This fact alone breaks my heart for my girls, for my family. So many dreams shattered, a future stolen. We will never get to see the amazing man that he was surely to become. His life was precious. Like I said, he was so much more than cargo. I pray daily for strength and perseverance for myself and for my family. I also pray that Mackenzie will find true remorse in her heart and true repentance. We thank all of those that worked so hard to help us bring justice for our son. We are forever thankful. Davion, we miss you terribly, but as Christians, we grieve with hope. We will make sure your memory lives on, and we ache for the day that we are united again in eternity. Thank you.
Hi, Your Honor. My name is Divine Flanagan. Davion was my older brother. The passing of Davion Markel Flanagan has been very difficult for me. We have gone through everything together since day one. Davion was a big brother to me and my younger sister, Delia. We all got adopted together in 2012. After Davion passed away, a lot of trauma and past pain has came into my life, causing it to be difficult to heal from this trauma event, or this traumatic event. Davion was not just a big brother to me, but a role model in many ways. He was the person I trusted the most because he made me feel safe. He taught me the importance of cherishing each moment and enjoying life. The memories we have are strong, but losing him has shown me the value of life. Here's how God works in ways you can't understand, but is worth it in the end. I don't want this pain for anyone else. I don't want people to have to go through this. As an 18-year-old, I hate the fact that he has gone because someone decided to take his life. Now that Davion is gone, I feel stuck. I feel as if I can't move forward. I feel lost. He was the one who picked me up when I fell. He was my best friend and the only person that has stayed with me since I was born. I would like you to give Mackenzie the longest possible sentence. I've known her for about 3 years, and she's always taken the easy way out. You shouldn't be able to take the easy way out when it comes to murder. It's completely unfair that no matter what sentence you give her, she will be eligible for parole, while my brother will be gone forever. Thank you, Your Honor.
I'm Christine Russo. I'm Dominic's mother. No one wanted this to be a murder or to punish Mackenzie Shirilla for this accident. But this was not a car accident. The evidence and science proved that Mackenzie Shirilla murdered my son, Dominic, as well as Davion. There's no fix put in this case, as the Shirillas would like to proclaim. I want to thank Strongsville Police Department and the state of Ohio for seeking the truth behind this crash. Thanks to them, we all know what happened in that car that day. What we don't know is why. I wish I could change this every day. I lost 3 children in that crash. Not a minute goes by each day that I don't think about my son, as well as Davion. My heart is forever broken. The cries heard from the Shirilla family and friends after the verdict are nothing more than a lack of remorse. Mackenzie Shirilla had a choice. Dom and Davion did not. We are all left here to mourn. But what Dominic and Davion lost can never be remedied in any way or by any particular sentence. July 31st, 2022, I called Mackenzie's mother, hysterical with the loss of my son and Davion. I knew Mackenzie was in the hospital, and the first statement said to me was, "Oh, please don't listen to what everyone's saying on Facebook." Yeah, my son is dead, his friend is dead, and I'm checking on yours. That social media is what's important. Social media has made a game out of the life of Mackenzie and is making a game out of this heart-wrenching tragedy. No one can imagine the pain of losing a child unless they've lost one themselves. The pain is forevermore. Time does not heal this wound. Mackenzie, going to prison because you did this. Be thankful that you're still alive and have a future, whatever that may be. Dom and Davion were robbed of their futures, their hopes, and their dreams. Mackenzie showed no mercy on Dominic, nor did she on Davion. Only God at this time can have mercy on her soul. Thank you.
Yes. Should my name? Is there a microphone right here? My name is Angelo Russo. I'm one of Dominic's older brothers, and I'm speaking today for myself and also on the behalf of our siblings and our friends. Sorry. Dom may have been young, but he made the most of each day and had an impact on the lives of his friends and his family. Dom was a businessman, an athlete, a song producer, and an entrepreneur. Dom was not only my brother, he was also my best friend, and the friends in this courtroom also say Dom was their best friend. Many of my brother's interests and goals were centered on learning more about himself and how he could become a better person. He was always doing what he could to learn about others, how he could understand different situations, different cultures, and how he could better the community. He read from various authors every day and even recommended to me countless books that have made me a better person and helped me understand the world better. A few months before he passed, he told me that he soon planned on joining a branch of the military. Admittingly, I was against this, but he felt the need to not only serve the community, but also his country. He gave me countless advice, and he also helped with anything and everything. Nothing said or done here today can describe the loss or repair our lives after this tragedy. Kenzie's statement in the hospital to Detective Azu, "Can't you just take my license away for 10 years or something?" That statement is Mackenzie Shirilla. The most selfish person I know. Ironically, Dom was the most selfless person I know. Mackenzie Shirilla murdered Dom and Davion in cold blood and had already moved on. Kenzie killed Dom over the thought of losing him, and she made Davion collateral damage. She was driving, going to concerts, and dressing up for Halloween, no thoughts of the families and lives that she had destroyed. As I said, Dom read a book every day. He started 2 companies. He recorded his own music, as well as recording music with myself and with friends. Dom helped anyone who ever needed a hand. He was an inspiration to everyone who had the honor of meeting Dominic. We love you, Dom. We love you, Davion. And God bless the both of you. Thank you so much.
I paused it right here to comment so far on the victim impact statements, and from what I can tell, the defendant in this case, Mackenzie Shirilla, was not the best person that she might have claimed to be, and some of the statements she may have made back that statement up. So this is just another these impact statements are carrying a lot of weight. So we'll just as we go through, we'll just have to wait to see what the judge says about this.
I have, Your Honor.
No, Your Honor. I have.
Was evidence from the defendant's cell phone. There were search warrants executed on her various social media accounts, her school records, her medical records, things of this nature. And I think that who she actually was is directly contradictory to what is painted by the letter submitted on behalf of her today. One moment. I'm sorry, Judge, I thought we were set on this. That's good.
I'm not even cool. I'm just one of those girls that can do a lot of drugs and not die. Gotta figure like a penny, gotta figure like the dog. Don't care if you think I'm dumb, I don't care at all. Candy best, sweetie, but I wanna be adored. I'm the girl you die for.
Objection, Judge. None of this was introduced in the trial.
Shortly after the crash, Strongsville police were notified that they had received concerning emails from the community that the defendant and her mother were seeking employment with the Los Angeles modeling agency. Kenzie Shirilla said to Vitaly, "Thank you for the comment. I would love to work with you guys. I've been emailing you guys a lot. Such a great opportunity. Thank you."
Is there a date
There is not a date on this, Your Honor. Based on the investigation, it was delivered to the police while the defendant was still in the Metro Health Hospital. So it was during that time period. She was in the hospital for several weeks. Shortly after being released from the hospital, the police were provided additional videos of the defendant from her wheelchair as she attended a concert down in the Flats. And again, Your Honor, I'm introducing these to the court to show the shocking lack of remorse. This was something that was being exhibited while the investigation was still going on, before she was charged and arrested in November of last year. And these were the sort of things that were coming to the police, and the shocking lack of remorse, coupled with the fact that the defendant was reported driving an automobile shortly after this event, that she was seen in Strongsville again driving a car. In spite of the fact that, as her mother testified, she got dizzy sometimes from a condition that she had to take salt pills for, in spite of the fact that it was, in fact, her mother who provided her with the car that she used to take Dominic and Davion's life. Halloween of last year, again, still before being charged, Mackenzie Shirilla celebrated Halloween with her friends at Ohio.
Baby, that's all we need. We go to the dog, at the dog, smoke that tumbleweed. At the Judge,
can I just make one continued objection?
Sure.
Thank you.
So it's showing so far that this young lady had absolutely no care for what she had done, or the lives that was costly in that. She's just going on about her business, going on about her life, and doesn't want to take any kind of accountability for herself.
Are these post?
These are on Halloween of last year, so these would be post-crash, just before she was charged in November. We think the defendant has shown a shocking lack of remorse, Your Honor. We think that she has continually put forward that this was an accident, in spite of the fact that the evidence is in direct contradiction. Your Honor, you were on Progress Drive. You saw the evidence that was displayed in court. And Your Honor, we think that you are the person who is in the best position to decide an appropriate sentence. We have full confidence in the sentence that you'll give her. Thank you.
Your Honor, may it please the court, I ask you to allow Mrs. Shirilla to address the court first.
My name is Natalie Shirilla. I just want to say, am I allowed to address them at all? I just want to say to the families that I'm broken, sad, and lost, and my heart hurts for everyone, okay? Davion was her new friend, and Dom was the love of her life, and he was part of our family, okay? I'm just so sorry that this happened, and we're heartbroken, okay? And then, Your Honor, this was a terrible, tragic nightmare accident to have happened that she has no memory of, and she will never emotionally or physically recover from it. She almost died too. And we're asking that you please not run the sentence as consecutive. He was family, and we all loved each other. That morning of the accident, she called. I got a phone call that there was a car accident. Okay, so we went to the hospital, and I didn't even know who was in the car. The names had not been confirmed yet. And I'm gonna cry because I missed Dom so much. We loved him so much. So I called Dom, like over and over again, praying that he was going to answer the phone, and he didn't answer the phone. So then I tried to call his mom, and she didn't answer the phone either. And I still didn't know who was in the car. I didn't even know if she was alive. I didn't know what was happening. So then we were in the waiting room, and then his mom ended up, She did call me, so I answered the phone and I was like, oh my God, like, I don't even know who was in the car. Like, what's happening? Was that Dom? And she said, what do you mean? My son is dead. And I was like, I'm so sorry. And then she said something like, and now I have to wait until your kid's out of the hospital. And then I didn't hear the rest. I was like, we loved him so much. And I hung up the phone. I did not talk about social media. I didn't even know what was going on yet. Okay? So then that was it. So in the hospital, that Vitality post, I commented on that because somebody had called her a murderer, okay? And she's not a murderer, so she didn't even have her phone at that point because the police had still had it, okay? So I jumped on and I was like, you know, she's not a murderer. She's more sad than hurt than most of these people commenting. She's been trying to get in touch with you. I mean, at that point, it was just an accident. So I commented on her behalf, not because of the modeling opportunity. Who cares about that? I don't want them to refer to her as a murderer, okay? And I don't even know how that comment got on the phone because the police still had her device and she could not access her phone or social media. That's why I did it. And I had called them asking if they could shut down social media because people were calling her a murderer and making death threats and organizing groups to, you know, take her out when she got out of the hospital and stuff. So I don't even want her phone. I don't care about her phone. I don't care about social media. I just wanted them to stop calling her a murderer so that when she did come to, and she did come out of surgery, multiple surgeries, that she wouldn't see all these people calling her a murderer because she would never, ever, ever murder the love of her life, okay? Halloween, for 3 months after the accident, she would only wear his clothes. She would only eat the snacks he ate. She would only listen to the music he wrote, okay? She was laying in bed for 3 months crying. There was a shrine of him next to her with photos and things that he liked and this flower that lights up that he got her because he wanted it to be fresh and alive forever. It's like a little Beauty and the Beast flower. Okay, she's got this shrine of him next to her. So she was crying for 3 months. So her friends asked if she wanted to go out trick-or-treating or Halloween, and it was at OU. And
So her mom right now is giving a statement to pretty much defend her daughter's actions in the hopes that the judge would be a little lenient in her sentencing. Usually moms will make the biggest impact, but in my opinion, I don't see that impact kicking in here.
she didn't even want to go. She said, I don't know, should I go? She couldn't even walk yet, barely. So I told her, I said, baby, please go. It's Halloween. You've been laying for 3 months crying, only listening to his music. Please go have just a moment of fun. A moment of fun. So we told her to go. My husband drove her. I brought her back home. She just needed a second of fun from losing her whole world. Her whole world. So that was us. We told her to go. And that concert she went to with Dom's cousin, Abby, they picked her up. They brought her there. That was Dom, Mackenzie and Dom and Abby all decided to go to this concert together while they were in the hospital. That was for Dom. Everything she did after the accident was either in honor of him, to be close to him, or just be by him any way that she can.
Now that's a statement I'm gonna go ahead and dispute right there. How is her going out to going out to party for Dom? How is her doing what everything that the mom just described for the guy she killed in the car crash? Let alone the second person that was killed. If anything, again, my opinion only, but if anything, she did it for her. 1 and 2, it didn't take much encouragement for her to go out and act like nothing was wrong.
She's like devastated and tragic. He was the air that she breathes. Okay, and they went with his cousin. We spent all kinds of time with him after the accident. What was the other thing?
I'm hearing an awful lot about your daughter, not hearing very much about Dominic.
Dominic, okay, I'm asking you for leniency because this was a tragic accident that she does not remember. And Davion, he's a new friend. I'm so sorry.
Does that mean his life is worthless?
No. God, no, not at all. They all loved each other. They all spent every day together. You know what I mean? I don't know too much for him.
Isn't that part of the problem, Mrs. Shaw?
Sorry?
Isn't that part of the problem, that they all trusted each other? Isn't that part of it?
It's not a problem at all. It was
It's a
wonderful.
problem of how they all ended up in the car together, or two of them ended up together.
I understand. I understand what it looks like. I'm saying that it was a tragic accident. She would never.
We're going to have to disagree.
I understand.
Right. And I respect her position.
I understand. But anyway, that's it. I just wanted to address those. We told her to go to those things, and then she did go with Dom's family. So look at that. Don't look at it with the look on that with different eyes if you can, please.
Those things are not relevant.
Not at all. Not at all. Not at all. But she's a good. If you would have a moment, all you would need is 5 minutes of a conversation to have with her to learn who she is. You would just need 5 minutes to learn who she is and what she's capable of not doing and doing, and you would see for yourself.
You know that's saying that you never get a second chance to make a first impression. Believe it or not, that saying actually applies here. And from what we've seen in the video evidence taken after the victim impact statements, and listening to mom plead on her daughter's behalf, me personally, that her first impression is already made.
That's all. I'm so sorry, guys. I'm sorry. I love you.
Yes, please. No, Jim, I have nothing to say.
It's okay. That's okay.
Is there anyone else?
I would like Mackenzie to address the court.
Mackenzie, you don't have to speak if you don't want to. It's up to you.
I would love to. Okay. You want me to stand up right here, John?
Sit if you want.
Okay. The families of Dom and Davion, I'm so deeply sorry. I hope one day you can see I would never let this happen or do it on purpose. I wish I could remember what happened. I'm just so sorry. I'm heartbroken. I love Dom and Davion. We were all friends, and Dom was my soulmate. I wish I could take all your pain away, and I'm so sorry. And to my family, thank you for the support and all the love you guys give. Thank you for fighting with me. I love you all so much. All right, I'm done. Thank you, girl.
If I could address the court, Judge. Your Honor, may it please the court. First of all, I'd like to extend my condolences to the Russo and Flanagan family. I can't imagine how difficult this is. It's terrible. People's acts have consequences, and the consequences here are up to you. You have a range of possibilities as it relates to a girl who was 17 at the time, who is now 19 years old and has no criminal record. And as you so correctly pointed out in the opening, the decision when she gets out is up to the parole board. And we know how the parole board operates, and we know that everybody gets flopped at least once. So a 15-year sentence becomes a 20-year sentence at minimum. And it'll be up to this young lady here as to how she's going to conduct herself for the next 20 years or whatever the sentence would be. That would be number one. Second of all, I'd like to say thank you so much for allowing and taking the time to read those letters. And I would like to concentrate on the letters from the people from juvenile court. First of all, Ms. Smith and Ms. Kent. They have been the people who have monitored her progress since she was entered the juvenile detention facility, where she was for about 9 months. And I would like to commend them for writing these letters, because ultimately, or initially, I tried to have them send a letter, and the people at juvenile court wouldn't let them. And so they sent these letters anyways. And what do we see from their letters? We actually see where both of them say that she expressed remorse during the time. What the prosecutor played there was after the accident and way before she was ever incarcerated. They also both say that they have observed her grow as a person, that she's taken every single class possible, both culinary and college, that she's actually been a model inmate, the letters say, and that she has exhibited what they call the highest level of behavior. They grade people 1, 2, 3, 4. The better your behavior, the higher the number. She has always received the highest number. She's also been receptive to counseling, and as Ms. Kent said, she has been making amends. I'd ask you to pay special attention to the letter from Kelly Leitner that I think talks about certain, she cites certain things. Ms. Leitner is asking you to consider that the brain is not fully developed until 25 years or older. Her choices, Mackenzie's, and actions are indicative of teenage invincibility. While, based upon your decision, you don't find that, I find that there are, I remember when I was young, the dumbest things I ever did, and I'd hate to be judged for those things. So really now I'm going to give you my observations, because I understand what you talked with Mackenzie's mother about acceptance of responsibility, etc. All I can tell you is that from the moment I met this young lady here, she expressed sorrow. And I would say during the course of this trial, in the initial emails and statements, she said, "I'm sorry for what you did." The prosecutor has said that she hasn't accepted responsibility. Well, as you remember, during the course of this trial, our defense was that it was a reckless homicide. That's taking responsibility for what she believes happened. So I would respectfully disagree with that. I've seen her express true remorse in the times that I met her in jail, and I don't think it's self-serving. And I'm going to say, as an officer of the court, that I feel very confident saying that she has expressed true remorse. So ultimately, another thing that you have to ask for is the likelihood of recidivism, etc. Based upon all of those things, I respectfully request that you run the sentences concurrently. Thank you.
Not on behalf of the state, Your Honor.
No, Your Honor.
Okay, we've heard the victim impact statements. We've seen extra evidence, if you want to call it that, from the prosecutor. We've heard from Mackenzie's mother, and now we've heard from Mackenzie herself. We've heard one last statement from her defense attorney, and now this one is in the hands of the judge. So I'm gonna leave that. I'm gonna leave that right now.
Today is the sentencing of the defendant for the purposeful and intentional murders of Davion Flanagan and Dominic Rousseau. And in a way, it's the second time their families are gathered again to grieve. It's also a day when Mackenzie's family will grieve for the future of their lives. All three of these families and the friends of these families are suffering, and all of their lives have been irrevocably changed because of the actions of the defendant. The unintended and collateral consequences of a selfish, intentional decision by Mackenzie will ripple forever in time. It's literally changed history because it's ended two lives. Two young men are dead. Their deaths were horrible, terrifying, tragic. I will say again, if any reasonable person reviews Exhibit 802, there can be no doubt in their mind what happened this night. There can be no doubt of the absolute terror of the two people in that car. The defendant controlled all the events. She chose the day. Specifically, she chose the day just before her 18th birthday. She chose to drive a car, the time to drive a car. She chose an obscure, previously scouted route through an industrial parkway. She chose the target to hit and the victims. She chose the means and method to follow through. She planned and purposefully executed the events of July 31st, 2022. A review of the evidence supports the factual findings, the forensic testimony, the testimony of first responders, the testimony of the emergency room doctors who treated the defendant, the testimony of the coroner's medical examiner, the testimony of those who knew the victims, the defendant, and the testimony of the BMV official who provided evidence that not only did the defendant deny a medical condition when applying for a license, which her mother co-signed and attested to, but also that just after the accident, Mackenzie renewed her driver's license and again denied any medical condition. In fact, the defendant was so concerned about driving that, as the state mentioned during the investigation, she asked if they could just suspend her license for 10 years. It is hard to fathom how a person could be concerned about the driving privileges, having just been responsible for the death of 2 people. There was no medical condition that caused this as an accident. There was no mechanical failure of the car. The record is clear on the facts and the evidence. Her mother's uncorroborated statement without any medical testimony or records is not persuasive. It is also important to remember that even if Mackenzie intended to also die in this crash, that is irrelevant. A failed suicide attempt is not a defense to murder. And even in a murder-suicide attempt, the perpetrator executing the plan survives. The other deaths are still murder. There's only one person who's responsible for the pain of everyone in this room. That person is your Mackenzie. Nobody else is responsible. This isn't the fault of Dominic's family, or Davion's family, or your family. And I know that each of you have asked your questions to yourselves, what if I had done this or that? The truth of it is, none of us can control the intentions of another. And when there is a purposeful intent to harm or kill someone, it is the perpetrator alone who bears the responsibility for the choice and the consequences and the harm that follows. The difficulty for sentencing today, honestly, is whether or not I believe you should get consecutive sentences. I'm troubled that should I give you a concurrent sentence, that people will believe that somehow I'm being disrespectful to one of the victims. And on the other hand, I have to weigh the punishment. There's a very good likelihood that you will spend the rest of your life in prison. That won't be up to me. That will be up to the parole board. That will be up to you to a great extent. I understand that the pain in this room wants me to impose the harshest sentence. But I don't believe that would be the appropriate sentence. Because I do believe that Mackenzie will not be out for 15 years. So she's sentenced on count 2, the murder of Davion Flanagan, 15 years to life. She's sentenced on count 1, the murder of Dominic Russo, 15 years to life, to be served concurrent to each other with credit for time served. I'll waive fines, fees, and costs, and your appellate counsel will be served. Are there any questions from the state?
No, Your Honor. Thank you.
Any questions?
No, Your Honor.
All right, thank you.
So there you have it. Mackenzie Striller serving 15 years to life in prison for the deaths of her former boyfriend and his other friend. Decisions have consequences, good and bad. And just because you have teen at the end of your age doesn't mean you're not going to be susceptible to the consequences. So now we move onward. Oh boy. This one I'm gonna have to do in bites. We've covered Alexi Treviso so far, and a lot of it is sickening to me. So here's what. So now we have a motion hearing as far as her defense goes, and we are going to dive in to see exactly what the motions are for in this case. The video you're gonna see is coming courtesy of the Law and Crime Network. So as always, I'm gonna have to put up the old copyright disclaimer. And here we go.
Okay, good afternoon. I see Mr. Mitchell. Got a lot of people. There's Miss Luce. She's also signing in. Is that your client in the background, Mr. Mitchell?
It is.
Okay, all right. Okay, thank you, sir. Just want to be sure we got our necessary parties here. Let me call our case number. This is, excuse me, CR 2023-159, State versus Alexi Treviso. Diana Luce is a district attorney. She's appearing for the state. Mr. Gary Mitchell appears as counsel for the defendant, and she is also appearing in person, virtually in person. So, counsel, we've got several matters to go through this afternoon, several motions. I wonder, do you have a preference as to the order? I was proposing we deal with the venue change as the first order, but if you have something else you'd rather take in any other order, I'm fine with that.
No, Your Honor, I can do with the venue. It'll be pretty quick.
Okay, all right, okay. So it's your motion, Mr. Mitchell. I'll let you tell me what I need to know that I'll hear from Ms. Luce. And I do have your pleadings here, of course.
Sure, and I'm not going to repeat those. Your Honor, classically, we'd have a hearing over whether or not Eddy County is free from exception, and I'd file affidavits and do all that. But the new basis for doing these change of venue motions virtually has turned into something that was suggested several decades ago by judges like Allen and some of those judges. Whenever we would, they suggested that rather than do change of venue motions, that we send out and ask the courts for questionnaires, and we send out questionnaires that we ask people to fill out under oath, and then the counsel reviews those questionnaires to see if by perchance we can get a jury, which seems to be much cheaper and frankly a better way to do it. Ms. Luce kindly sent me the latest questionnaire that they used in a similar case out of Hobbs or out of Lovington. I got that. She and I can make some modifications to that. The trial date you sent earlier today is acceptable to me. I think it's acceptable to Ms. Luce, and we can figure out with you and the court clerk when we should send those questionnaires out via Google, however we're going to do them. That's up to the clerk, but I'll get with Ms. Luce. We can work up that jury questionnaire, get it sent out once we get the new panels that would be sitting for that trial. And then when we get the information, we can figure out when counsel can sit down and go through that with the court, move to strike certain jurors who, by the answers on the jury questionnaires, have given us sufficient information for which they could not sit fairly and impartially, and decide if we have enough jurors to select from, and then go from there. I would propose that to the court as a way to resolve this issue rather than have a lengthy hearing today over whether or not this case has nationwide publicity, countywide publicity, statewide publicity, or world publicity. It has all of them, frankly. So trying to move to another jurisdiction may not, in New Mexico, may not be very suitable, since the whole state has some of the same media sources, and particular social media has been so explicit in this particular instance. That's the solution I propose.
All right. And are you on board with that, Ms. Luce? I mean, it sounds rational. We all know there's no place to go that somebody hasn't heard about the case, which is that's not the standard for qualifying or disqualifying, but nevertheless, there's no place we can go that would be any different, my opinion, than Eddy County. And I think that's what I'm hearing from Mr. Mitchell. Are you on board at least with the concepts?
Yes, Your Honor. That's why I provided the supplemental questionnaire we used in the case that we tried in Lovington, so that he could see the questions we did. Obviously, he and I can confer. If we can't agree, then on it, we can have a hearing before the court. But I think if we can agree, then we can just submit it for the court's approval. The court can submit it to the clerk's office, and then they'll digitally upload it, as they did in Lovington, and then they'll send it out paper for jurors that need that. But I think that resolves that motion for today.
Okay. And folks, let me it's above my pay grade. I don't know how Martha does her work down in the clerk's office, but my suggestion is that we get with her early enough, and this trial's not going anytime soon, so we should have adequate time to let her know we're going to have to get an unusually large number of jurors pulled in to examine a panel. I mean, just the length of the trial alone is going to make it difficult to get an adequate veneer to pick from. So at least we've got some ramp up time, and then I'll let Martha know, kind of be warned, we're going to have a really, really large number of prospective jurors to sort out, I think, in this case, just to get enough people to sit on a panel. And I think you told me you expected 6 weeks to try this. Is that right?
That's what I estimated, but a lot of that goes to jury selection. But if we do, and I found, I don't know if Ms. Luce has found this to be the solution as well. I found if we do a decent supplemental jury questionnaire, that cuts down on the amount of time we need for voir dire. So we may be able to get it done within 4 weeks if we're not having to do.
So you're counting the 6 weeks, a good part of that you're counting also pulling the jury, right?
I am.
Okay. So the extra trial portion won't be 6 weeks. You were accounting for finding a jury to sit.
Right. I counted 2 weeks for jury selection.
Okay. All right. Well, we will keep that in mind, and I will just try to start anticipating and plan ahead as much as possible on getting that taken care of. Okay. All right. So that issue's off the table. I've got 2 other pending motions. I have the one to modify conditions of release. Then I have the other, which is the motion to suppress, motion for protective order, exercise of privilege, and the Pena-Espinosa procedure determination. Which one do you want to handle next?
Jeez, all those motions, and this is getting crazy. Now this judge looks like she's got a little sense about her. Will it keep up? That's the question. Keep watching.
You're muted, Mr. Mitchell.
Let's do the privilege one next. It's
okay.
All of them, because I think I can argue the whole thing, and we'll save the release provisions to last. There's also a motion that I filed. The state didn't respond, but to take the deposition of one of these, I'll think here just a second. The toxicology experts that's in Pennsylvania. The state sent some of their lab tests to Pennsylvania, and I didn't want to be without that expert for whatever reason. But that's something we can do later. But we probably need to take the deposition for purposes of trial of that particular witness. So we're not either one of us hung out to dry when we need that toxicologist, and we don't have them available because they're more than 300 miles away.
So this is a toxicologist for the state, and you need the deposition of this toxicologist. Am I right on understanding that?
Right. At the preliminary hearing in this matter, the state objected to my just getting into that with the forensic pathologist and or any other doctor, saying we needed to have the toxicologist here. I want to avoid that. I've dealt with that issue with the same toxicology group before, where we tried to bring them from Pennsylvania or the state tried to bring them from Pennsylvania. And normally somebody calls me and says, Gary, can we take their statement or their deposition? And that's all I'm saying. We just need to take the deposition.
Okay, but that's not right for today. We're going to have to put that up for another hearing, right?
That's right, Judge. I'll talk to Diane about it, to the district attorney about it, see if we can reach an accommodation, if we can take that witness's deposition and introduce the report. The report's what I need or the state may need, whichever one of us needs it. Thank you.
Okay. All right.
I'm ready to argue on this motion to exercise of privilege. Let me say, and there was some confusion yesterday, but we didn't send these exhibits, but to the court via your email and to the district attorney via her email. So these are exhibits I still think need to be sealed for purposes, but I sent exhibits A through I just for the purposes of this hearing. They're not to be admitted at trial or anything. I'm not asking that. Just for purposes of the hearing. They included the records of the hospital, which I think are privileged, and for the court's edification, the two lab reports that we needed. And then we had certain police reports, and I noticed and looking here, both officers are present. I guess we could take their testimony if we need to, but I attached their reports, Williams and Anaya. And then there's a videotape that the state doesn't have that I'm aware of, nor do I have, but I've seen on people send it on social media. It's from Artesia General Hospital, and it's a videotape of my client going from a examining room down the hall to the bathroom and then coming back. Another Artesia police officer took that tape, figured out a time schedule. That's Exhibit G, a timeline. I believe that was Officer Minter, and I attached his report showing the timeline. And then there's the videotape that we seek to suppress, where police officers, the doctor, and my client are and her mother are in the examining room. That's the Miranda issues. And then I did a timeline of events to give the court, without you having to examine every medical record, to give you a timeline of what we're talking about here. So I'm asking that those be admitted for purposes of this hearing and that they be sealed.
All right. You have any objection, Ms. Luce?
Your Honor, I don't have objection to the video, to the police reports, to the lab reports for purposes of this hearing. The timeline that has a caption on it appears to be Mr. Mitchell's work product summary of what everything purports to be and purports to happen. If that's a proffer by him of what evidence is, and the court is to consider it only as a proffer, the state doesn't have an objection. Otherwise, that's basically argument. And the state's going to object to that being a written document, with us only getting it last night coming in before the court.
Okay, I saw a thumbs up, from Mr. Mitchell, right?
Judge, and I knew that, and I expected to just use it as a proffer of what the records show. Ms. Luce didn't say anything about Exhibit A, which are the medical records that came from Artesia. I copied those straight from what the state gave to me. So I don't know if the state has an objection to those. You're going to have to look at them some point in time to decide what is going to be admissible and not admissible under the privilege.
Now, counsel, I don't have any of these actual exhibits you're referencing. Where are they? Have you tendered them?
We sent them to your TCA via email today, and she should have them.
You did? Okay, she said she sent them to my email. Let me check. I'm sorry, I missed them on my email if she did. Hang on a minute, let me look.
It's a lot. It took several emails. I think we put them on a.
I'm not sure. I've got one that does not appear. It's a reference. Here's the link for Exhibit F. That's not it, right?
Well, there's an Exhibit F, but we put them on a link for purposes of the court. I didn't anticipate that you'd be able to go through them all. I figured you might take some under advisement after you heard from counsel today.
I will do. And Emily, will you do this? Print them up for me. Just print them in. We'll put them in a folder also, because it just helps me to have them in hard form. She'll get them up and I'll look at them later. Will that work for you folks as far as this goes?
It will, Judge, because the argument is going to be, anyway.
Okay.
I do need to know if the state objects to Exhibit A, which were their medical records.
Your Honor, not for purposes of this hearing, for the court to consider them. Of any objection to any of these, as I've let defense counsel know, being sealed, not public for purposes of the record for various reasons. And so I don't have a problem with that, Your Honor, but I just wanted to make sure that the one that is, I believe, the timeline of events was the proffer to the court. Since it had a caption on it, it appeared to be prepared by Mr. Mitchell or along with his staff.
It was prepared by me, Judge, and a proffer is all it is. And
Okay.
That's really put the style of the case on it. So
Okay. Okay.
All right.
So, all right. With that said, let me hear your argument, Mr.
Sure, Judge, and I'll be as succinct as possible. When the court reviews the argument that Ms. Luce made regarding HIPAA and the argument I made, we both agree under the law there's not a remedy under HIPAA for one exercising the privilege. There are fines that a hospital and doctors pay for violation of HIPAA, but that has to do with the Department of Justice and their investigation and Medicare and Medicaid and whatever they decide to do. But for the individual, there's no remedy under federal law under HIPAA that you could exercise. You can't sue for damages or anything like that. So my purpose in bringing this today, however, is under New Mexico law, and I cited the court to this. Rule 11504 is a physician-patient privilege in the state of New Mexico that we believe applies. And I, in my brief, cited the court to Bertrand and Roper, which are the two key cases for the exercise of that privilege. Our position is we have not waived this privilege in any way. We did not sign a waiver. It applies to the doctor. It applies to all hospital personnel. It applies to Artesia General Hospital. And later on, it applies to the hospital in Roswell where she was taken. So and that's one reason I attached a timeline so the court could know. This entire case hinges around what happens in a bathroom and the emergency room of Artesia General Hospital on the date in question, which was January 27th of 2023. The timeline will tell you that there's one admission sheet that says 12:03, but by 12:05, she's in the emergency room. And then within a few minutes, she receives medication and through an IV, and including morphine and several other different kinds of medication. It's a timeline would reflect. Without getting into that too much, she She's examined by an emergency room doctor. She has a nurse that's there. People come in. The hospital asks for a UA, and blood. They do a blood test, and by 12:51, they know that she's pregnant. And then we know, when it comes to this privilege, that according to and they happen to have a video camera or some type of camera in the emergency room part of Artesia General Hospital that shows her leaving her room. And we know from the records that at 1:39, she leaves they go in, they unhook her from the IV, let her get up. She virtually runs down the hall, trots down the hall to the bathroom. And then, according to the police report that you have from Officer Minter of the Artesia.
I pause there because I'm saying this. It sounds and looks like to me he's making his case for the civil case in which Alexi plans on suing the hospital where she was at because of how they got the information regarding her being pregnant, how they found the baby dead, and all this other nonsense. And I call it nonsense on Alexi's part. Here's where the nonsense comes in, ladies and gentlemen. If I've said it once, I've said it over 100 times as this case unfolded. We need to stop looking at Alexi Treviso as a little kid. She's 19 years of age. She's a grown woman. And that grown woman knew exactly what she was doing. She did all this cover your behind stuff to try to keep her mother from figuring out she was pregnant, to keep her schoolmates from knowing she was pregnant, to keep her boyfriend from knowing she was pregnant. But come on, let me go ahead and say this. Stevie Wonder could figure that out. Stevie Wonder could figure that out. Stop treating her like a little kid. It's time for her to own up to what she did.
There's a police department who reviews that video and goes through it. She's in the bathroom for approximately 18 minutes and then leaves the bathroom and goes back to her room and then by a certain time period, and let me pull that up so I can speak intelligently to the court. We know that after the 18 minutes in the bathroom, we know she's back in the room, and we know that emergency room personnel go in and begin, the cleaning staff goes in and they begin to clean the bathroom. And later and that begins at 2:08. And then by 2:27, they find the baby. And at 2:38, the doctor pronounces death. And then police arrive after that. So when the police arrive, the doctor wants to wait for the police to get there. I don't think this is disputed at all. She waits to talk to the two officers from Artesia Police Department, both of whom I've attached their reports, the sergeant and the officer that came in. And I've attached those as exhibits. So they come in, they talk to the doctor, and then they go in the room where she is. And the doctor walks up to her and asks her and tells her they found the baby and asks her, says something to her. You have the videotape of that. It's a lengthy videotape for you to examine of that time period with the officers there. The officers both say in their report that they told her she was detained, could not leave, and for purposes of Miranda, I would argue in custody and not free to leave, which means that at no time is there anything read about Miranda, which gets us to the suppression issue. But back to the privilege, the key question is to determine, when does this privilege apply? Well, it applied from the first time she went to the hospital. That's real clear under the rule and under the case law, and it applies to everybody there. And really the state's case is the time in the bathroom. And then it applies afterwards as well. So my position to the court is everything that takes place between the time she goes to the hospital all the way through is privileged information that the doctors and the nurses could not give out to Artesia Police Department, could not give out to anybody without a waiver from my client, and we've never waived it. In addition,
now, are you talking statements made by her and her medical records?
yes, Your Honor, and that would also include lab reports and stuff.
Okay.
Anything that happens at Artesia General Hospital, and there's a case on that as well that says, hey, that includes lab
Yeah, I
reports.
want to look at the annotations. I don't see that. I'll have to pull it. Let me ask you another question. Is information, because obviously cleaning staff, what, about 2 hours after the event? Is that what you said? They go in around 2 in the morning?
Yes,
And then around a little past midnight, cleaning staff goes in around 2-ish, right?
That's correct.
And they discover the deceased child.
Yes, after they're in the, I can tell you the exact times on that based upon the records and stuff. At 2:08 in the morning, the ER staff, janitorial staff started cleaning the bathroom. At 2:27, they call in a male nurse because of what they found in the bathroom. They found the baby, and then that nurse takes the baby into an examining room. And at 2:38, the doctor pronounces the baby deceased.
So let me ask this. Notwithstanding a doctor-patient privilege, what about the hospital's obligation to report the deceased child? Is that privilege? Are you claiming that as, okay, that's where I was headed. Okay.
They have a duty to report it. They call 911. It turns out that the police were there. The emergency room wasn't busy, but it turns out they were real close by anyway. And they were there quickly. But no, they have an obligation to report it. I'm not saying that. I'm saying this, and I'll try to be as succinct as possible. Really, the state's case hinges on what happens in the bathroom, and there are no other witnesses but my client to that. And whatever the experts are saying, whether it's OMI, my experts, and such, are going to say about that. But basically, that's the situation, is that for that 18 minutes, there are no other witnesses. But everything before that, because there's no case before, she doesn't have the baby except in the bathroom, Judge. That's the point. And before that, there were no issues that I think aren't covered by the privilege. And then after that, obviously, they end up taking her to a room. Obviously, people see all the blood, and they realize they have to do some examination. The doctor goes in, doesn't talk to her because they don't know that she had a baby, but they think there may be other complications. And then after they confront her, the doctor and the 2 police officers in her room, then after that, the doctor intervenes again and says, listen, I got to helicopter her. We got to airback her to Roswell. We don't have people here in this hospital to take care of it, and she is bleeding to death if we don't get her treatment at Loveless and Roswell. So they airbacked her to Roswell after that. And of course, the police let that happen, although she was in custody at the time that they went into the room. The doctor specifically states in the reports, and this is not in dispute because it's in the records and it's in the police reports, The doctor deliberately waits after they find the baby. The doctor deliberately waits until, and no other staff goes in until police officers arrived, and they all go in at one time. And that's where we get into the Miranda issues. So for the privilege, I'm saying everything's privileged up to the time she goes into the bathroom. Everything's privileged after she comes out, because it's all part of the privilege.
Okay, now let me stop you here because I want to clarify. I'm looking at 0504. We have the doctor-patient privilege. This is an exception to the other rules. Who has the obligation? Does the doctor, and is this in case law? I'm not seeing it here in the privilege. It says who may claim the privilege. Is the doctor obligated under this act or anything else to invoke it, or at least advise the patient of their privilege, or invoke it on behalf of their patient? What is their obligation?
The doctor and the hospital's obligation is, until they have a proper waiver of that privilege, they can't talk about it. And here's,
and then she has to make a knowing waiver after being advised what her right is in event to waive it.
Well,
right?
There's no case law on what a knowing waiver is. That's always been, did she sign a waiver?
Okay.
You know, we've always done that on a case-by-case basis. I'm not going to tell you that I have a.
For those who are just joining in on the chat, we're right in the thick of Alexi Treviso's motion hearing. So good to have you here. Bethea'S Byte Reloaded, your true crime drama-free destination.
Particular case, although having done this in civil cases and in other cases classically, there's a written waiver that is signed that you can waive that, and that's not done in this case. And my client is not a child. She was 19 at the time. They had the waiver from her. They never got it. And here's the problem for all of us in this case. Okay. There's a huge problem. Is mass media, social media, how it got out is, I guess, an issue that the district attorney and I will have to look to sooner or later. But the truth is, it got out. All these records, all these videos were out. Now, somebody from Artesia had to disclose that. Every one of them gave a statement to police. They shouldn't have without a waiver. They all gave records they shouldn't have without a waiver. They gave a video they shouldn't have without a waiver. Or and classically, when you read the case law, there are three ways. Number one, you get a waiver from the patient. Number two, a court orders it. There is no court orders in this case. They didn't go down and say, Judge, we need a search warrant. We need an order from you, ordering the hospital to turn over the stuff to us. They never did that. They just did it. And then, in fact, there's a videotape in this case where the officer goes in and asks the administrator of the hospital, what do I need to do? He says, well, just send me an email. That doesn't cut it. It doesn't cut it under HIPAA. It doesn't cut it under this rule. So my point is that the privilege applies. Now, I could choose to waive part of that as her attorney, or she could waive part of it. We haven't chosen to waive any of this. And as a matter of fact, the state knows this. At the very beginning of the preliminary hearing in this case and the motion, what I did was
what seems to be muted out is probably.
Mr. Mitchell, I was muted. You're muted. Something happened. I don't know what. Can you repeat everything you just said? I am sorry. It just my screen muted you.
I don't know how long I was muted for, but here.
Let's go back about 60 seconds, I think.
Well,
I'm sorry.
Here's the point, Judge. I've never waived this on behalf of my client. My client's never waived it. At the preliminary hearing in this matter, and the motion to set conditions of release, I objected right before we ever got started receiving evidence to the court exercising the privilege, alerting the court to the issue, alerting the court to HIPAA, alerting the court to the doctor-patient privilege, and my belief that it covered Artesia General Hospital in this case.
Mhm.
And he gave me a continuing objection throughout the entire hearing, and I've never waived it since then, and I've never waived it before this court. So that's what we think is covered by the privilege. So all these medical records, all of these statements by doctors and nurses that were taken without waiver, all of the lab reports, not the state lab reports, not those that come on the examination of the baby, but those that were examination of my client, that would be the blood test results, pregnancy test results, things of that particular nature. All of that is privileged. Everything there is privileged and should never have been disclosed. And we need a determination from the court that it's privileged. And if the court decides it's privileged, then unless I waive it, or there's another, and I don't know of any other reason, because the privilege is a privilege, under Roper and Burchard and the rule, that remains privilege and cannot be used in court. So that's the argument on the privilege. And I'll submit it to the court in that regard. And then we can argue the suppression issue later.
Okay. All right. Thank you. And I'm looking at the act. Privilege is that to be claimed by the patient or their guardian or custodian, which doesn't apply. It's a personal right by the patient. And it says who may assert the privilege on their behalf would be their physician or whoever treats them. Authority to claim the privilege is presumed, absent evidence to the contrary. Exceptions, well, it says by order of the court. Okay, so I understand what I'm looking at. Let me hear your side of this argument, Ms. Luce.
Your Honor, basically defense in their motion raised three issues. They raised the issue of Miranda, they raised the issue of HIPAA, and they raised the issue of privilege by the rule. Mm-hmm. Let me start with the issue of Miranda. Okay. The issue of Miranda, she was not in custody. Statements that she made once the police were there were actually statements initially that she blurted out. Officers asked her no questions. And then her mother, who is present with her in the treating room the entire time, is saying things to her. And the officers actually tell the mother to stop, that she, has Miranda rights and that she should be advised. And so we think the Miranda issue is really not an issue. There's not a violation of Miranda. And we put that in our response. The second thing is HIPAA. The defense puts HIPAA in here. HIPAA is really a red hearing. It has nothing to do with the criminal case. There's no remedy. It's not a constitutional protection. It's a statutory protection in which a penalty can be against the facility, the physician, and that is the civil suit that two civil suits, I believe, that defense counsel has already.
Yeah, and I think Mr. Mitchell doesn't disagree with you on that point.
Right. Well, no, but he put it in his motion, Your Honor, and so
okay,
for the purposes of the record, the state's just making an argument.
He acknowledged to me that the HIPAA is a separate, it's a federal issue, it's a remedy that doesn't even run to the patient, apparently.
Right.
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 I understand. Okay.
So it really had no place in his motion, but it was there. So the third is the rule. And so let's start with the defense has kind of combined a lot of things together. Statements made by treating personnel, doctors, nurses, records, video. He's kind of lumped all that together. The state doesn't believe that's proper. First of all, the defendant's mother, this defendant is an adult, the defendant's mother was present at all times. You can't have privilege if a third party is present in the room. And so.
You just went mute again. I'm having trouble with this. I think it's our system. Okay, go ahead. It's about 10 seconds. Okay, go ahead.
The defendant's mother is present in the room with her at the emergency room. She's not with her in the restroom, but she's with her when the nurses, doctors, anyone is speaking with her. You can't have a privilege if you have a third party present. You've already, by your own actions, letting your own mother be there, waived that privilege. So statements that are made are not going to be protected under this rule. She's an adult. If she was a minor, that would be different. So statements, that's one thing.
You're muted again.
Records, the hospital records, the police department was given the records, but they did apply for a search warrant and obtain records properly by court order.
I pause here just to make a statement that apparently they have their own issues too. The defense attorney was muted. The prosecutor is muted. I believe the judge may be even muted at some point. So we got to be careful as we go forward.
And so a claim of privilege that we didn't get them by court order for a crime, the state believes that that is the exception and allows us to use those tests from the lab as well as the records. The third thing is apparently the claim of the security video for the hospital for the hallway. The state would submit.
You're muted again. Okay, go ahead.
Yeah, Your Honor, it's showing that there's somebody on as a participant that is muting people, just so that the court knows.
Okay, that's good to know. If anybody's trying to mute, please stop messing with the system, all right? You can mute yourselves, but please don't mute my litigants here. All right, go ahead.
So, Your Honor, the video in the hallway, defense is arguing that that video is privileged. The hallway would be a public corridor within the hospital. It's not a private patient room. It wasn't the restroom. The fact that other people can access that hallway and be in that hallway, we don't believe that there's any right of patient physician confidentiality for a public hallway. It wouldn't be any different than when the court has a closed proceeding in the courtroom. Whatever's going on in the hallway of the courthouse is not a protected, secluded area. And so for them to try to argue that because it shows a bathroom in the hallway where she comes in and out of, that doesn't make it patient protected privilege. So I think really you have to separate out the three.
Again, go ahead.
The three types of evidence involved, from statements that are made where her mother is in the room and then later the police are in the room. It's definitely argument for defense counsel to say that the doctors deliberately, intentionally waited for the police to go in. I think that's probably at this point an assumption on behalf of defense counsel because we've had no doctor testimony to say that. But either way, the fact that the mother was already in the room, there's no right of privilege. There's no claim of privilege that's been waived. She came with her mother. She allowed her mother to be present. The court would be familiar that a patient has a right to not have other people in their room. They ask if it's okay if that person stays. That's normal treatment. The state would submit. So, Your Honor, we believe there are three different things going on here. And for defense to lump it all in and say it's all privilege before the court, we would disagree. And so we don't believe there is a privilege based on our argument to the court. I do have the officers on if the court wants to hear from them, since it is a motion to suppress of what happened once they were there. Once they were in the room, they were then had body camera. The report has been submitted. I don't know if the court deems that sufficient. If you want to hear from them, that the state is glad to put on these witnesses. We would also ask, Your Honor, to be able to submit proposed findings and conclusions, because this is a rather intricate argument, and I believe the way the defense has framed it and the way the state is framing it are very different. Thank you.
All right. It is apparent to me there may be some distinct acts or events that occurred that are privileged or may be privileged. I'm seeing other. I can't lump this into one event, a long-running event. I think we've got, for example, I'm thinking the whatever happened in the hallway, which I think is just a video of her going from, I guess, a treatment area down the hallway into the bathroom. Right? That's a public area. I can't see that video would in itself be a privileged video. I've got other questions about other parts. I do think it's a good idea that you submit findings of fact in this case. I'm going to go back to you, Mr. Mitchell. I've got to tell you, I don't know how much of it I did see, but I was aware, I think it was around the time the pretrial detention hearing was occurring, which I did not conduct. That was not assigned to me. That was Judge Finger. There was something on the news, one of the Albuquerque channels, which I think was the video you're referencing. I think there was a physician, ER, I guess he was an ER physician.
Judge, you're on mute.
Yeah, I just was. Who is
something? Jad.
Okay, somebody named Jad SD56 is muting us. Please stop. I'm going to have to ask him to leave this hearing.
He just left the meeting, Your Honor.
Okay. Well, that helps.
And Judge, you were asking a question when you went on mute.
Yeah, I think I was telling you that that's not part of. I was just passing through a room in my house, and there was some news report. This was immediately after the pretrial detention hearing was conducted, and it shows a video. It shows I think it's the ER doctor. I don't know. I believe it was, and there was a police officer. I thought it was a state policeman, a police officer, and there was conversation going on. That's about all I know about that. That's the one you're referencing. Is that right, Mr. Mitchell? That she was
No. That came from an interview later on when the police are interviewing the various nursing staff. That's a charge nurse that you're talking about. That you were talking to. He also was the one that took the baby from the bathroom into an examining room and called the doctor to come down. That's a charge nurse.
So talk to me about. Here's what I have on my mind about the state alleges that Ms. Treviso waived any privilege by allowing her mother in the room when she was in this. You say it was custodial investigation or interrogation. She was. Does anybody dispute? She was advised she was not free to go. Right? Is that undisputed?
Well, they say so in their reports. And Judge, I gave you the video. You have the video among the exhibits I produced.
Oh, okay. Okay, I'll see that later then. So
you can see exactly what happened. But really, in answer to the court's question, number one, my client's mother came with her into the emergency room.
Mm-hmm.
She was present, except when she went down into the bathroom. She was not present in the bathroom.
Mm-hmm.
She was present during most of this. And then she was present later on when the doctor and the two police officers come into the room. Now, I want to be real clear about these facts. After 18 minutes, you see my client go down the hallway to the bathroom, and then 18 minutes later, she leaves the bathroom, and she comes down and goes back into the examining room. Now, the doctor went into the examining room to do a quick vaginal exam because they didn't know what had happened. They had not.
I'm pausing right here to pretty much declare that that the defense attorney seemed like to me he's already pleading the case in this hearing in order to try to get what he's looking for, like a change of venue, and this, that, and the third in this motion hearing. But I'm saying save all that for the trial that's coming up. Save that same energy for Alexi's defense.
I found the baby at that time.
Okay.
And they do a quick vaginal. She gets undressed. They do a vaginal exam. None of that's recorded, obviously, on video. It's in the privacy of the room. The doctor's there, but they have not found the baby yet. And so, again, the mother's present. Then I'm going to be upfront about this. And then the clinic staff finds the baby, and then they call the charge nurse. The charge nurse takes the baby into an examining room, and then calls the doctor. And then it's after that. And this was testified to, and I know I say this very respectfully to Diana. She wasn't the attorney that handled the preliminary hearing.
You're muted again.
I don't know what's going on there, but I'll keep my finger on it, Judge.
No, I'm not touching a thing. And
we may have so many people on there that's the problem. Anyway, I was saying that after they find the baby, then it's when the doctor, who also testified at the preliminary hearing, indicated she waited after they found the baby to go back and talk to her patient, my client, until police got there. They called 911. The police were there. We're not talking about a lengthy period of time here. We're talking about within minutes, really quick. And the police were there. The sergeant comes, the officer comes, and then then they talk to the doctor. They go in the room, and in the room at the time is my client, her mother, the doctor, and the two police officers are standing, and she can't leave. And that's in their reports that by that time they've got this information. They have a baby that's deceased. They have a doctor. They have the baby, and they have information, and they're going in to talk to the mother.
And let me interrupt you there now. Ms. Luce has asserted that because her mother apparently was already in the room, that statements made by your client were, I guess, impliedly waived because her mother was, and she's an adult. I think it's based on that. I mean, if she were a minor, a different situation altogether. Can you address that?
I can, and you need to address it in ways. Number one, what does the presence of the mother do to the medical doctor-patient privilege? That's number one. Number two, what does it do under Miranda suppression rules? Well, the latter first. Under Miranda, it doesn't matter who's present. They have to read her when she's in custody and she couldn't leave. The officers were there. They say it in their reports. And then they don't read her Miranda. The doctor asks a question. And you can't do that. I've cited some cases and wrote on that in the response or the reply to the response. And that's a different situation. And Miranda was still.
You're muted again.
Again.
And whether or not that gets suppressed or not is the determination the courts to make. That's a different and separate issue. Now, does the privilege at the hospital apply with the doctors and everything, with the mother being present? My position is, I'll try to do some further research on this. I agree with Diana. We need to do findings and conclusions and give you some case law about this. They're not deciding this thing in a vacuum. But my position is the doctor-patient privilege still applies because we do this all the time in hospitals. We have spouses present. We have family members present because they brought them in. And a lot of times the people aren't in their right mind to make decisions anyway and need a family advisor. We do this in hospitals all the time. I'm sorry, it doesn't get. Wow.
Well, okay, you're good.
Wow. It doesn't get rid of the privilege. It's my position.
All right, that's what I really, and that's going to be a real important factor for me to examine and I do think before I make any really hard decisions, you're getting my impressions on stuff, but I would really like to have your finding of facts, conclusions of law before I really have studied this. So that's something I'd like both sides to give me some authority on about that. Is it impliedly waived if you allow another person in the room? All right.
All right, Judge, I think the other issue was that you had before you today was a modification of the release provisions. Tried to avoid that problem this semester because I didn't have an order and hadn't had this heard before then. But I'm asking that the court take a look at the motion and the state's response, because one, I don't believe we can order that in that fashion because of the cases cited to the court, including Johnson and some other cases. And two, she has not violated that whatsoever. The judge allowed him to communicate via telephone and or, gosh, there's so many different media ways to communicate, but they couldn't be in person. And she's honored that. She doesn't go out at all other than to come to my office. The court allowed her to go see her grandparents. And other than that, she's at home. She doesn't go out. You don't see her at Walmart, anywhere else. But going to college and of course, her professors, even though she's doing this Zoom, I'm not sure what they're going to require when it comes time for examinations as to whether she can do those via that method or she has to go to down to the university and take examinations. We're trying to avoid all those problems this semester, but in any event, we have some time to consider this, Judge, but wow. In case you need to have more time to look at it, or the state needs more time. But I would ask that restriction of being able to have contact and with your boyfriend be removed, and that and the other reason for bringing this is I didn't want her to get in trouble in another city because they run across each other in a classroom or on the campus, even if it were by accident. We're just trying to do everything up front. There's not been any issue otherwise. Thank you, Judge.
Okay, let me ask you some questions because I'm kind of limited on what I can pull up and do my own research while I have my screens up here. I can't quite do that. It says I guess the authority the prohibition was issued is under 3311B. Can you summarize that for me? What is that?
That is the domestic violence statute. Let me hang on just a second, Judge. I can pull it up real quick. Let me get to the argument. Give me just a split second here.
Your Honor, it's the nature of the relationship. That's what the court was citing to in the conditions of release at the pretrial detention, defining continuing personal relationship.
That is correct. But my point is, this is not a domestic violence situation between the two of them whatsoever.
Mm-hmm.
And that statute shouldn't apply. What should apply is that we can't, she hasn't been convicted of anything. She's not on probation. And as long as they don't discuss the case, they should be able to see one another. And that kind of prohibition, and I don't want to get into all the marriage equality cases, but those are the cases in which really the rights that you have in that regard have been explicitly spelled out by our Supreme Court in the cases that I've cited to the court. All right.
Okay. Well, I was wondering because I was thinking that was under some domestic relations ruling. That's what I thought. Okay. So this is under the DB statute? That's the authority that was used to prohibit the contact. It's not because he's the potential witness. Is that right, Ms. Luce? He's not going to be a witness in the case.
Your Honor, he could be a witness, but at the point that Judge Finger made in the findings, he mirrored what Judge Shoebridge did in the Alexis Sevilla case, was that he did not want her to have a relationship that could result in pregnancy. And we end up in a similar situation again as to what had occurred. That is what Judge Finger was doing in restricting. It was restricting contact. And the state disagrees with defense counsel that the court doesn't have the authority to do that. The analogy would be a DWI case and the court saying you cannot consume alcoholic beverages while this case is pending. Once probable cause is found and probable cause has been found, this court can set restrictions to ensure that there is no conduct that could lead to a further crime involved in the case. And that is why Judge Finger made that restriction. He used that definition because they weren't married, maybe they weren't officially boyfriend girlfriend. He used that continuing personal relationship to say that she was not to have that. The court can look at what happened in the Alexis Sevilla case of Lovington with Judge Shoebridge. He specifically restricted her from having any contact with any male individuals that were not family individuals. Obviously, she had people that lived in her home with her. Because of the nature of what had happened, recognizing in that case that child survived. This case is different. And so the state believes that the court can fashion conditions of release that allows her to attend a university that the same individual could attend. Maybe they're in the same class, maybe they're in the same lab, the same bookstore, the same restaurant, but it's no different. There's no reason for her to have a relationship with this person based on what the facts of this case are at this time. They haven't made any showing that there's any. They didn't bring him in to testify. They didn't bring in a proffer of what's going on. And Your Honor, we believe that condition is appropriate based on these circumstances. You remember, part of the state's case that we believe that is not privileged are her statements she made without being questioned by a doctor, without being questioned by law enforcement. She volunteered statements that she would not have to be given Miranda before she's volunteering a statement. She alleges she's not pregnant. She's not had sex. All those things. So we believe it's an appropriate condition of release. We believe the court can say that she can be in the same classroom with him. She can attend the same campus. That's not what the restriction is.
But it only runs us to this one person in this case, right?
That's right, Judge. It only runs to one person. And I don't want to get into other medical privileges that she has. Suffice it to say, I have made certain that she's had proper medical care since. And with doctors that I have lots of confidence in, in a different community. And
Well,
the Judge Finger was confronting and his fear. We've taken great steps to make certain that doesn't happen.
well, I would really like to look at this more, but I'm going to go ahead and I'm going to modify the conditions of release. I'll allow her to go. It's New Mexico State and Las Cruces, right?
That's correct, Your Honor, it is.
Big university, huge. I don't know what the student count is, but I'm sure it's several thousand. Las Cruces is a sizable city. Personally, counsel, I'm really trying to get in my mind how you can invoke a domestic violence prohibition against personal contact. First off, nobody's invoked the DV statute. There's been no allegation of domestic violence. I don't think that translates into this. I really don't. My gut reaction is that does not translate. Granted, you can order that anybody who's under charges cannot commit any further criminal acts. I certainly think that's absolutely reasonable. She should get her conditions revoked if she gets charged with any further criminal acts, but I don't see how the DV statutes can even be applied in this case, notwithstanding what Judge Schubert said originally or anything else. Certainly, she commits any other criminal act, she should have her conditions of release reviewed, absolutely. But I really don't think that a DV statute defining continuing personal relationship and prohibiting such can be translated into this situation. That's my read on it. Honestly, I think you can stretch that. I do advise that she may not commit any other criminal acts of any sort. I don't want her to get a traffic ticket or anything else. I'll let her go to Mexico State. That's a big, big university.
Thank you, Judge. I'll do an order on it. Judge, how many days or weeks may Ms. Luce and I have to do findings and conclusions? And I assume the state would rather I proceed with mine first so they can respond, but I don't care how we want to do it.
How do you want to do this? I wish I had a good clerk to help me with my legal research. You know, this is all on me, so you got little old me doing this too. So,
well, Judge, what if I have my Ms. Lewis? What suggestions do you have for when we?
How long do you need to get a findings of fact to me?
Okay. Well, Your Honor, we usually do 2 weeks, and then we'll give the. It's going to go to the second.
Got somebody. All right, I'm going to mute them.
If you're going to
Someone
have.
has been trying to get in and out constantly by using our names on here.
Folks, I need everyone to mute other than counsel. Thank you.
Your Honor, 2 weeks is fine. I can get mine to the court in 2 weeks.
Okay.
And conclusions on these issues.
All right.
And I'll do the orders on the others.
Okay.
And
then, Your Honor, if we can have an additional week before we have to file our findings and conclusions.
Sure, that's fine.
That's fine with me, Judge. And do we want to do anything on that deposition situation today, Ms. Luce, or would you rather we wait on that and you and I just talk?
Your Honor, I would ask that if we can't come to an agreement on it, that we set that at a later date.
Sure, that's fine. Okay. I got to tell you, both counsel, and I really do appreciate you're both rational, competent, really good attorneys, and I really enjoy having you in my court, and you save this court a whole lot of headache. I appreciate that. That's duly noted.
All right. That's all I had for today.
Okay. Somebody. Isabel is having a little hissy fit here on our sound system, I guess. I don't know who Isabel is. All right. Okay, counsel. And Miss Luce's screen. Okay, no, she hadn't. It was frozen for a second. All right. If you'll all prepare me the appropriate orders, what I'm taking under advisement is the issues on the suppression motion and privilege motion. And you'll submit findings of fact to me in 2 weeks and then an additional week after that. All right.
Yes, Your Honor. Thank you.
Okay, thank you, folks. I appreciate you.
Thank you.
Okay, thank you. We'll be in recess.
And there you have it on that one, ladies and gentlemen. She'll take under advisement the suppression and privilege motions. The motions for new venue, that's been denied. The trial will begin on October 2nd, and Alexi, lucky as she is allowed to travel to Las Cruces for college just as long as she doesn't commit a crime between now and time for trial. We'll see how that works out. We got a case out of Springfield, Massachusetts, where a woman was killed and three other children were hurt at that moment. Now, before I do that, before I bring any video up, I want to pull the article first. And as I do that, I want you to get a good look at both the victim and the assailant. There we go. There's that. Okay. A Massachusetts woman was killed and her 10-year-old granddaughter was critically injured in a suspected murder-suicide that also left a 34-year-old man dead, according to the Hampton District Attorney. DA Anthony Gallooni said in a press conference that Victor Nieves forcibly entered his neighbor's apartment in Springfield and began firing at the occupants, including Kim Fairbanks, age 52, and her 3 grandchildren, ages 12, 10, and 5, and their dog. Nieves then turned the gun on himself. Fairbanks and the family's dog were killed, while two of her grandchildren were injured. The 10-year-old, who authorities have not publicly identified, was airlifted to Boston Children's Hospital, where she was in critical condition. The 12-year-old was also shot, but is in stable condition at Springfield Hospital. The third grandchild, a 5-year-old boy, was uninjured in the attack. I remain deeply saddened by this tragic attack, and I am profoundly sorry for these children and their family members, Gallooni said in a statement. This is unequivocally one of the most heinous and cowardly acts to which I have had to bear witness as a district attorney. My heart goes out to the parents of these children and the family and loved ones of Ms. Fairbanks. As investigators, we will do everything we can to support this family as we move forward and close the criminal investigation. Kim, wife, daughter, mother, grandmother, and friend, was tragically stolen from her family and friends, wrote the GoFundMe's organizer Natasha Lopez. Her life was taken while babysitting her 3 beloved grandchildren. Since it was posted, the GoFundMe has raised over $7,000. It is seeking to help raise money for funeral and medical costs, as well as other day-to-day expenses. In the GoFundMe description, Lopez wrote that the oldest grandchild sprung into action and protected her siblings as best she could. Springfield Mayor Dominic Sarno thanked the first responders who helped save the children in a statement, and also expressed condolences to the family. I have spoken to the mother of the children who were seriously harmed by an unprovoked and despicable attack put forth by Victor Nieves to, first of all, offer my support, thoughts, prayers, and encouragement to her and her family. Also, my sympathy to the loss of the children's grandmother, Kim Fairbanks. Fairbanks is being remembered as a caring mother and grandmother with a great sense of humor. Kim was so proud of her children and grandchildren, wrote Lopez. Kim would go to war for the people she loved, and she died doing so. Kim lives on through all of us, and we will remember her as a hero. Then I got this update confirming what I'm about to report next. A 10-year-old girl critically injured in the suspected Massachusetts murder-suicide has died days after the incident, according to a Facebook post from the girl's mother and news reports from NBC 10 Boston, WWLP.com, and the Associated Press. The Hampton District Attorney's Office said the girl had been shot by Victor Nieves, who forcibly entered his neighbor's apartment in Springfield Monday. Fired at the occupants include 52-year-old Kim Fairbanks, 3 children, and their dog. 34-year-old Nieves then turned the gun on herself. The girl, identified as Aubriana Lynn by her mother's post and also by Springfield Mayor Dominic Sarno, had died on last Thursday, days after she was critically injured in the shooting. At 12:56, my princess Aubriana Lynn's heart stopped beating, wrote her mother, Stephanie Croteau, on Facebook. It was peaceful. She was not in any pain. She was surrounded by her family. My whole heart has been completely ripped out of my chest. Aubriana had been airlifted to Boston Children's Hospital prior to her death. Anyway, an update on the GoFundMe for that case. Since it was posted on last Tuesday, the GoFundMe has raised over $31,000, seeking to raise money for funeral costs as well as day-to-day expenses. It's sad. It's a sad moment. Here's the brief report from at the start of this case.
Police have now identified the man who opened fire on his downstairs neighbors, killing a grandmother and wounding 2 of her grandchildren in Springfield. Police say this man here, 34-year-old Victor Nieves, forced his way into the home through the front door and then began shooting, killing 52-year-old Kim Fairbanks before taking his own life. A 10-year-old girl who was shot is in critical condition. A 12-year-old girl who was also wounded is in stable condition. And a 5-year-old boy who was in the home at the time was not hurt. Police have not yet released a motive behind that attack.
We start with breaking news tonight, a heartbreaking update on Monday's murder-suicide in Springfield. According to the Hampden District Attorney's Office, we now know the 10-year-old child wounded in that shooting has died.
Monday afternoon, a neighbor identified as 34-year-old Victor Nieves shot himself, a woman and 2 children in their apartment on Berkshire Avenue. Upon arrival, officers entered the first-floor apartment and found an adult woman, 52-year-old Kim Fairbanks of Springfield, and an adult man on the floor, who both died due to gunshot wounds. A dog was also found dead, and Fairbanks was the grandmother of the 3 siblings that were found in that bedroom, ages 12, 10, and 5. They were taken to Bay State Medical Center.
Heartbreaking barely scratches the surface of the emotion felt in that one. And I have one last story to get to before I get out of here. And this one is coming out of Texas. There we go. And 1 second, guys. I want you all to take a look at this little face right here. This was 11-year-old Maria Gonzalez. 4 teenagers charged on a drive-by shooting. Oh no! I'm showing you the wrong picture. Wrong picture. Hold on, guys. Wrong picture. There we go. This is the girl in the story. All right, this was 5-year-old Galilea Samiego. There we go. 4 teenagers charged in a drive-by shooting that killed this girl while she slept in a trailer. It says 4 teenagers have been charged in the death of 5-year-old Galilea Samaniego, a New Mexico girl killed in a drive-by shooting in Albuquerque while sleeping in a trailer home, according to authorities. At a Monday press conference, officials with the Albuquerque Police Department announced the arrest of 2 boys, ages 15 and 16, on charges of murder, conspiracy, and other shooting-related offenses. This is according to a Facebook live stream from the Albuquerque Police Department and a report from the Associated Press. 2 brothers, ages 15 and 17, are still being sought by authorities on the same charges. The teens all 4 teens are not being identified due to their age. Police said they believe the girl was not targeted and that shots rang out during a dispute that escalated between the 2 teenagers, one of whom lived at the trailer home with Galilea. We determined early on that a teenager who lived at the residence was the target of the shooting. According to that's what Deputy Chief Cicely Barker said at the press conference, adding that there were different families who were staying at the trailer home with the young girl. On August 13th, around 6 a.m., Galilea was sleeping in a trailer home at the Vista del Sol mobile home park when the teens who were inside 2 stolen Kia Souls began firing. One of the bullets went through the trailer and hit Galilea in the head. She was later pronounced dead at the hospital, according to police. Police determined the Kia Souls were stolen the night before the shootings. Barker added that investigators were able to tie the shell casings to several incidents involving the same juvenile suspects. At this time in the investigation, police said it's unclear how the teenage suspects were able to obtain the guns. If you see something, say something, Barker told reporters, and when asked what neighborhood residents should do to help police prevent future shootings like this. We all bear responsibility in this community. If you have kids in your neighborhood who you might know might be struggling, please reach out to them. Let's work together as a community to come together and fight violent crime, especially when it involves our youth, the deputy chief added. I think we owe it to each other. A GoFundMe campaign has been created to help offset funeral costs for Galilea's surviving family members. According to her obituary, she is survived by her parents, 3 siblings, and grandparents. And it's heartbreaking. It's absolutely heartbreaking reading stories like this. Or even hearing about it. Need further proof? Check this out. There. This young lady here was a story. Was one I was ready to tell you about earlier. Do I have the article with me? Yes, I do. Yes, I do. All right. The article says that an 18-year-old man suspected of sexually assaulting and killing an 11-year-old girl in Pasadena, Texas, was arrested in Louisiana on this past Saturday. He's facing a capital murder charge upon extradition. Police in Pasadena had previously been searching for Juan Carlos Garcia Rodriguez in connection with the death of Maria Gonzalez, you see on the screen. That's according to the department. Maria's body was found by her father, Carmelo Gonzalez, who was returning home from work on the afternoon of August 12th. Her body was found under a bed in their apartment, wrapped in a plastic trash bag. Carmelo left for work that morning and had been communicating with his daughter via text message, the Pasadena Police Department, according to the Pasadena Police Department. The last text he received from her was Maria telling her father that someone was knocking at her door. After her body was found, a key that didn't work on any of the doors was also found in the apartment. Pasadena police said in a release that the medical examiner determined that Maria had been strangled and essayed. Days later, in a subsequent release, police named Garcia Rodriguez a person of interest, saying that he resided in the same apartment complex as Gonzalez, but had since left the property. A warrant was later issued for Garcia Rodriguez's arrest, who was arrested in Shreveport, Louisiana, after the Harris County District Attorney's Office filed a capital murder charge against him. Garcia Rodriguez is still in custody in Louisiana, according to jail records, and is awaiting extradition back to Texas. It is not immediately clear if he's retained an attorney. Now, like I said, it's heartbreaking for me just reading stories like that. Imagine how it is when you hear it firsthand. I'm already all kinds of wrong. There we go. Let's try this again.
Well, they tell me this is just an awful situation. Police say that when the dad left for work, that was the last time he heard from his daughter, when she texted him saying that somebody was knocking on the door. And what they say, they said that there was no signs of forced entry. Families and police are trying to figure out who killed 11-year-old Maria Gonzalez at the small apartment complex on Main Street in Pasadena. Police say she was sexually assaulted. Carmelo Gonzalez is Maria's dad. Gonzalez told us Maria texted him after he left for work Saturday morning. She said someone was knocking on the door. Family members then went to check on her, but they didn't see or hear anything. Gonzalez finished his shift at work, and when he got home 5 hours later after that initial text, he says he found her dead, hidden under a bed.
Father's alibi checks out.
Police say at this time his alibi checks out and that he is not a suspect. Police told us federal investigators are helping to figure out what happened to Maria. DNA samples have been taken from people who live in the complex, but police said they're running into some roadblocks.
Getting cooperation has been frankly, somewhat of a challenge.
Gonzalez told us Maria's mom was in Guatemala when this happened. He says he doesn't understand how someone could do something this awful. He told us he is not going to rest until he figures out exactly what happened.
We don't know if they're operational.
There were security cameras, but police say it's unclear if they were working at the time. Reporting in Pasadena, Giovanni Ligi, ABC 13 Eyewitness News.
We also want to keep Maria's photo up for a moment here. Pasadena police chief says he has a child around her age and he's very concerned there are no arrests. As for those cameras at the complex, police say they may have been damaged in the storm a few months ago, but he says detectives are going through a mountain of digital evidence.
And of course, at that, there are new details in the case.
Tonight, the man accused of killing.
11-year-old Maria Gonzalez remains in a Louisiana jail awaiting extradition back to Texas. Maria's father is speaking out for the first time since the suspect's arrest. There are also new court documents in the case. Anayeli Ruiz is live in Pasadena tonight with more. Anayeli.
Well, we obtained those newly filed documents this evening, and they revealed the suspect lived across the hall from the victim the entire time. A sigh of relief for Carmelo Gonzalez and his family tonight, days after Louisiana police arrested the man accused of killing and sexually assaulting his daughter Maria.
Feliz porque ya le detuvieron y ya no anda ocasionando más daños a cada familia.
Carmelo, speaking out for the first time today, says he's happy 18-year-old Juan Carlos Garcia Rodriguez is now behind bars and hopes he doesn't hurt another family. Charging documents revealing new details that led investigators to their suspect. They say the day Carmelo found his daughter dead, he also found a key that didn't belong to them on the floor of their apartment. Investigators saying the neighboring apartment unit had changed their locks. And when they spoke to the two men at that apartment, they said their roommate Juan Carlos Rodriguez had moved out just days after Maria's murder, and he refused to return their key. And growing nervous, they changed the locks. Investigators say that key and those old locks matched. Tonight, I spoke with their roommates. They didn't want to talk on camera, but said Juan Carlos had only lived with them for less than a month.
Somebody must have been helping him because he made it to Louisiana without owning a vehicle.
Now, despite an arrest, the fight for Carmelo is still not over.
Y que no tenga piedad.
He's now hoping the suspect will find it in his heart to confess what he did and give them closure, and that judges keep Garcia Rodriguez in jail without a bond. Now, we do know investigators collected DNA at the scene. It's unclear if that DNA ties Juan Carlos Rodriguez to the crime scene. We'll still have to wait and see the results for that. By the way, he's still in jail in Louisiana, waiting to be extradited back here to Texas. Reporting live, Anayeli Ruiz, KHOU 11 News.
And of course, there will likely be more information coming regarding this case. And when I get it, you'll get it here, Bethea'S Byte Reloaded. For now, that's gonna wrap it up for me. I said I had a lot to go through. It was a long, arduous process, especially going through that motion hearing with Alexi Treviso. Yet, I'm proud. I have to pat myself on my back a little bit. I am proud of being able to go through it. As far as those the early stories I brought you, the updates regarding Daisha Turner and Sushi Staples, I say again, and I say it with all my heart, as you've seen throughout these last 3 hours, I take children's cases very, very seriously. Those children need justice as much as adults do. They deserve it. And in those first two stories, those 6 children, those 2 cases, more so than ever. One being left in a garbage can for 7 months, dead. And mom, I use air quotes calling her name out as mom. She kept it, she concealed it, she obstructed justice, and she's got to pay for it. The other, mom, leaving her children in a basement, age range from 14 months to 14 years, and each one of them weighing less than 55 pounds. The youngest one, just 10 pounds. That's neglect. That's abuse. And Daisha Turner, you need to go down for that as well. That's the reason why I do this. I seek justice for the children. Those are the cases I take the most serious. Don't get me wrong. I said I take it most serious because I've been through it. That doesn't mean I don't take any other case serious. I've been where those kids are, and it wasn't a pretty sight. So I thank you all for sticking with me. I thank you for joining me in the chat. Soul Shine for Jesus, Haunting Haley, everybody who joined in, everybody who's planning on watching the replay. You can hang for 3 hours. I appreciate you all. I gave it to you all in the chat as to how to get in contact with me through Facebook, X, formerly known as Twitter, here on YouTube, Instagram, TikTok, or by email. I'm gonna go ahead and get up out of here. I thank you so much. Let's do this again next time, same place. I love you guys. Take that, spread it around, and be good to yourself, be kind to yourself, be kind to others, be good to others. And to all my real good parents out there, like my man 50 Grand, Vinny Politan would say, whatever you do, don't forget to hug the kids. I'll catch you guys next time. Until then, you know what to do. Bite. Hey guys, this is the Last Outlaw saying thank you to all who have watched and subscribed to Bethea'S Byte Reloaded, your true crime and drama-free destination. I couldn't do this without you. Did you enjoy this video? Are you looking to get more information about what you have seen and heard here? Are you looking to give feedback as to how I can present this better? Here's what you do. Like this video. The more eyes on it, the more this information gets spread to others, which makes it a step closer to justice served. Share this to your social media. Again, with more eyes on this, the closer we get to seeing justice served. Drop me a comment. Whether it's on the topic or the presentation, I will respond to your theories and ideas. If you haven't subscribed yet, what are you waiting for? Hit the subscribe button to show your support for this little true crime engine, powered by you. Set your notifications to all for future videos. Be sure to follow Bethea'S Byte Reloaded all over social media. At Bethea'S Byte Reloaded True Crime on Facebook. At EKB316 on X, formerly known as Twitter. At Bethea'S Byte Reloaded on YouTube. At EKB316 on Instagram. At King of Hearts 316 2021 on TikTok. You can email me at kingofhearts316_09 at outlook.com. This is your home for news without the drama, your opinions, lively debates, your voice heard, and above all else, justice served. This is Bethea'S Byte, and it's reloaded.